To talk to you. So my name is Chris Soghoian. I'm the principal technologist at the ACLU, the American Civil Liberties Union. I work with a team of lawyers. I'm not a lawyer, but I work with a team of lawyers who do most of our surveillance and Fourth Amendment litigation. I'm a computer scientist that focuses specifically on surveillance, and I spent the previous 6 years studying how law enforcement agencies use internet and telephone companies to surveil their targets. The police don't go to your house anymore and spy on you. They ask Google or Verizon to do it for them. There we go. So I've been working on this set of issues for some time, and my community, the community of security researchers, have done a really bad job. We have made tools that are difficult to use. For several decades, there have existed many sophisticated security and privacy tools, but these were tools made by geeks for geeks. In the 90s, there was what we in our community call the crypto wars, a period in which the Department of Justice and people in the administration sought to regulate the export and use of strong cryptographic technology. In essence, as then Louis Freeh, the director of the FBI, he went to Congress and talked about a world in which terrorists and drug dealers and pedophiles could hide from government investigators through the use of email encryption and other sophisticated technology. And so for some period of time, they were seeking to ban or regulate this technology. So Louis Freeh's fears didn't really come about, although there have existed freely available tools for email encryption since the early to mid 90s. I suspect that many of you probably have never sent an encrypted email in your life, or if you have, it was a one-time thing that you tried out and then gave up when you couldn't convince your friends or loved ones to communicate with you. And this largely reflects the fact that encryption software is difficult to use. It's exceptionally difficult to use. There are usability taxes associated with it. The entire concept of public key encryption is something that many people just cannot get their heads around. And so people generally don't use these tools. And of course, what this has meant is that bulk surveillance by the intelligence community and by law enforcement agencies has been far easier than it really should have been. On a typical day, your web browsing activity, your emails, your instant messages, many of them will go over the internet without any form of encryption. And that makes the government's job really easy. I mean, if there is a take-home lesson from the past 9 months worth of Snowden revelations, it's that the difficult job facing NSA hasn't been collection, but rather how to process the vast amounts of data they've been able to collect. And that's because so much of what we do goes over the internet without any protection. Our telephone calls, our text messages are all unencrypted, just sitting there for governments, for criminals, for competitors to collect. And so it's been really sort of interesting to watch this slowly change. One of the sort of more interesting pieces of the Snowden story is that when Edward decided he was going to go to the press, he tried to reach out to Glenn Greenwald and ask Glenn, he sent Glenn an encrypted email, and Glenn didn't really have a way to open it. He then sent Glenn a YouTube how-to video that Snowden had made himself, teaching Greenwald how to encrypt his emails, how to use PGP. It's still unclear if Glenn watched the whole thing and couldn't figure it out, or if he just didn't care. But eventually Snowden had to go to Laura Poitras, who was a New York-based filmmaker who was slightly more sophisticated and knew how to use encryption software. And it took some convincing by Poitras to get Glenn to download this software and figure out how to use it. And as a technologist, I can tell you, this stuff is a pain in the ass. It is truly unpleasant to use email encryption. And you would have thought that DOJ surveillance of the Associated Press, DOJ investigating people like both Risen and Rosen, the New York Times and Fox reporters respectively, getting their emails, trying to discover their sources, you would have thought that increased investigation and surveillance of journalists by this administration, more than any other administration in history, would have prompted the news media to seek out and use digital security tools, but in fact they didn't do that. But in the last 8 months, I have received more encrypted emails from journalists than I've ever received combined in the previous 10 years that I've been working with journalists. And what's happened is in the wake of the Snowden revelations, the media, or at least journalists who work on national security and surveillance issues, have really started to get their game. They've started to use email encryption. They've started to encrypt documents stored on their computers. They've started to use encrypted messaging. Inside the ACLU, we are now using digital security tools, which means that when my colleagues are talking to clients, whether they're in Egypt or in Guantanamo Bay, obviously the Gitmo detainees cannot use encrypted communications, but when my lawyers are in Gitmo, they can call back to the central office using encrypted communication tools. And so we've seen a shift where media organizations are slowly starting to embrace these tools. Just today, the Washington Post had a story online revealing that the Post website will be moving to encrypted by default, which will prevent the government or employers or universities from knowing which articles people read. Surely something that is core protected First Amendment activity that the government has no business knowing. We are seeing the media finally starting to embrace this, embracing technologies that allow them to protect their sources, to shield their reporting activities before they are public from the government. But it took a little while. It took some really high-profile stories of mass surveillance, and it took, I think, a little bit of embarrassment for the media to realize just how bad they were. So I think there's something that journalists and lawyers have in common, and that is that typically they both know very little about technology. Of course, many lawyers have a lot more money than journalists. But while the media has slowly, has quickly embraced encryption and other technologies, the legal community has not done the same. In the last few weeks, I was performing an amateurish survey of websites of national security lawyers in the Washington, D.C. area, and I could not find a single one with a public encryption key on their website, although every national security reporter I know now proudly has their email encryption key in their Twitter bio and on their respective homepages. The legal community has been really slow to pick this up. Now, I understand email encryption is really difficult to use, but there are other kinds of security tools that are easy to use. And the easiest and most impactful of these is encryption for telephone calls. There are free or very cheap $10 a month apps that you can download onto your smartphone, to your iPad, that you can use as long as the other party has that app, and then you can make calls that are 100% encrypted. That means that if the government wishes to wiretap your attorney-client privileged communications, which they can and will in some cases, that they need to hack into your handset. They need to hack into your iPhone instead of just getting the communications as they go over the wire. There was a story just maybe a month and a half ago revealing that the Australian government had spied on communications between the Indonesian government and their lawyers in Washington, D.C. Of course, the Australians and the Americans and the Brits and the Canadians all share information, and so some of those attorney-client privileged communications made their way into NSA's databases. This revelation by the New York Times led to a very nasty letter from the ABA to the National Security Agency. And while that was good, while I think it's good that the ABA should complain about surveillance of lawyers, I don't really think that's enough. I think that you should never rely on the promises of intelligence agencies that they're not spying on you. And so I really think that the legal community needs to look at itself in the mirror and ask why it has been so slow to employ these technologies. If it takes $10 a month to have all-you-can-eat encrypted voice service, encrypted text messaging service, why are you not using this? Why are you not advertising your encrypted telephone number on your website? If you're charging your client $600 an hour, why does the first hour not include an iPod Touch with this encryption software pre-installed that you FedEx to your client and say, here, let's use this for all future communications? And I think the reason is because you've never really had to, and you've not been punished for not doing so. But I think times are changing, and I think your clients are going to start expecting more. I think we're not quite there to the point that you'll be sued for malpractice for not using these kinds of technologies, but in the same way that 10 years ago no one was installing disk encryption software on their laptops, and today every corporate IT department has this stuff pre-installed on devices that you're issued, I think we're getting there slowly. And so I think the real message from the Snowden revelations for this community is that you need to step up and start embracing these kinds of digital security tools. It's not rocket science. It's very easy, but you need to spend a little bit of money, and ask your IT department for help. Thank you very much.
Thanks, Chris. Time for one. Anyone have one question? One question?
Hi, it's more of a statement than a question, but thank you, that's very interesting. As a practicing attorney, in my engagement letter with my clients, I actually address the issue of potential for hacked email and or telephone conversations. I don't know how valid it would be if I were sued, but to at least acknowledge that it is possible, and at this point, since I'm not addressing it technologically, that they should be aware of it and they assent to it.
So I was looking at the website. I think it was Jones Day. I think that was the firm that the Indonesian government retained, but if I got it wrong, I apologize. I was looking at their website, and they do say, if you would like to use encryption, we can make it happen. But I think that's a cop-out. I think you are typically going to be more informed than your clients, and so you need to insist, and you need to make that stuff available. Just to say, oh, you should be aware of the risks, I think that's probably a very lawyerly approach. But come on, buy the software, install it, advertise your keys on your website. Have, you know, the encryption, the voice encryption software that we use in our office is called Silent Circle. I have no affiliation with the company, but it's $10 a month. It's easy to use, and frankly, it's sort of cool to have encrypted phone calls. You feel like a secret agent. There's no real downside. Thank you very much again.
Chris, I should tell you, we had a legal hackathon back in February, and one of the winners created a product that was essentially Snapchat for legal documents. So not subject to discovery, disappearing immediately. So, something, the future's there. All right. I know we've gone without a break for a while, but